don't see it like in any of.
Good afternoon, everyone. My name is Marie-Claude Jean-Baptiste, and I am the Director of the Human Rights and Access to Justice Program at the Vance Center. It is my pleasure to welcome you to our webinar today that we are co-hosting with our partner, the Global Center for the Responsibility to Protect. The event is titled Vadis, the Prosecution of Atrocity Crimes from Myanmar to Ukraine. And there is no doubt, and I think you will all agree, that this discussion is very timely and relevant. We are seeing in the US particularly a renewed interest for international justice and the prosecution of atrocity crimes after years of neglect, if not outright hostility. And just this morning, we learned that US Attorney General Merrick Garland is in Ukraine to discuss with his counterparts the prosecution of atrocity crimes in the context of that war. And in other conflicts as well, whether it's Ethiopia, Myanmar, Yemen, Syria, just to name a few, the scale of atrocities has really shocked the conscience of people all over the world. And everyone is asking, what do we do? And scholars and observers alike are putting forward several proposals. Do we create new ad hoc tribunals like we did in Rwanda and the former Yugoslavia? Do we reinforce and reform the existing institutions like the International Tribunal Court? People are expressing concerns about the stalemate at the UN Security Council with the use of the veto in conflict situations. Discussions about the role of domestic justice systems in prosecuting atrocity crimes using universal jurisdiction as a tool. How about victims? How do we make sure that their voices are being included in those discussions? And very interestingly, something that we are following very closely at the Vance Center, what we've seen in the use of the International Court of Justice as a forum to bring atrocity crimes related cases. All these questions are definitely worth asking. And today, our panel discussion offers an opportunity to really dig deeper into these issues with a panel of experts who have direct experience on engaging with these issues. So I hope that this webinar will leave you with some answers to these questions, but also a better understanding of the opportunities and the challenges that this historic moment for international justice presents. It is therefore my pleasure to introduce our moderator for today's discussion, Savita Pandey, who is the Executive Director of the Global Center for Responsibility to Protect, again, our co-host for this webinar. Savita is an expert on R2P and atrocity prevention, and she has a vast experience advising governments and the United Nations on how to prevent and respond to mass atrocities. Thank you so much, Savita, for co-hosting the event and moderating our panel. Many thanks to our panelists as well for taking time from your busy schedules to be with us today. We're very much looking forward to hearing from you. Savita, you have the floor.
Thank you, Marie-Claude, and it is our pleasure to co-host this event with the Vance Center for International Justice, and it is also my pleasure to moderate this event today. I would like to welcome our global virtual audience and also our very esteemed panelists. I'm hoping that, as Marie-Claude said, that this is going to be really a rich discussion with a varied set of stakeholders involved in the international justice processes of various sorts. Justice, accountability, and redress for atrocity crimes are necessary to deter the recurrence of atrocities and to consolidate post-conflict peace. Accountability for atrocity crimes is not only punitive, it is preventive. Ending impunity for atrocity crimes through criminal investigations and transitional justice processes can help deter the recurrence of such crimes. For victims and survivors, recognition of their suffering and accountability for violations and abuses perpetrated against them can have immense restorative value. Transitional justice initiatives that promote accountability, truth-telling, and reconciliation, as well as human rights protection, can address root causes of societal tensions and also address past grievances, which in turn support long-term goals of peace. Nonetheless, the multilateral system, as well as the individual member states, as Marie-Claude said earlier, continue to face obstacles in addressing impunity for atrocities around the world. In the 20 years since the Rome Statute of the International Criminal Court entered into force, and 17 years since the adoption of the responsibility to protect, conflicts in Myanmar, Ethiopia, Yemen, Syria, and most recently Ukraine have prompted renewed discussion on the effectiveness of the international criminal justice to deter atrocity crimes and to hold perpetrators to account. Several proposals have been put forward in order to increase the deterrent effect of justice, while the members of the international community are grappling with lessons learned to inform future accountability initiatives. Today, we hope to tackle some of these themes during a substantive discussion on the role of international tribunals, the UN, domestic prosecutions, as well as norms and principles, such as the responsibility to protect. How can they be better leveraged to deter and prosecute atrocity crimes? We are joined by 5 illustrious experts today. It's my great honor to welcome you all. The first expert I would like to introduce, a very dear friend of the Global Center, Ambassador Vance Center. He's a permanent representative of Croatia to the UN and the former UN Special Advisor on R2P and former Assistant Secretary General for Human Rights. Akila Radhakrishnan, President of the Global Justice Center. Karen Mosuti, Head of the Liaison Office of the ICC to the UN. M. Arsenal Suleiman, Counsel at Foley and Hogue, Counsel for the Gambia in its case against Myanmar at the International Court of Justice, and Catherine Gallagher, Senior Staff Attorney at the Center for Constitutional Rights. Each of these panelists have very unique areas of expertise and will share light on the numerous interconnected aspects of the international justice system. The format of the event is a Q&A format, and I will pose questions to each of the panelists. We will leave some time at the end of the discussion to take some questions from the floor. So please pose these questions. We encourage you to do so through the chat function on Zoom. So without much further ado, I will start by posing my first question to Ambassador Simonovic and Ms. Radhakrishnan. So this question is to both of you. Ambassador, if you would go first, and Akila, you second. So as the scale of atrocity crimes has grown and impunity for these crimes persists, the international community has attempted to pursue innovative methods and adopt new norms to deter and prevent atrocities. Given your extensive experience, what are the opportunities and challenges that arise when advocating for the establishment and implementation of new mechanisms and emerging norms like R2P?
Thank you, Madam Moderator. Dear organizers, co-organizers, I fully agree with you that we are heading in a dangerous direction. Relevant trends are negative and atrocity crimes are on the rise. We have a moral, political, and legal obligation to improve atrocity crimes prevention, as well as to ensure accountability for perpetrators should the crimes nevertheless occur. Accountability does not only help to provide justice to victims, it is also a very powerful deterrent and prevents future atrocities. On the other hand, impunity emboldens perpetrators as well as others to commit new crimes. Let us use a practical example. If there was accountability for aggression, annexation of Crimea in 2014, and crimes committed in Donbas from 2014 onwards, would there be a new wave of aggression and atrocity crimes committed in Ukraine starting from February 24th this year? How many lives and human misery could have been spared? And finally, what will be the consequences if there is no accountability this time yet again? When pursued properly, accountability deters future violations and supports reconciliation process and sustainable peace. Therefore, combating impunity and promoting justice and accountability are important components of our responsibility to protect populations from atrocity crimes. Accountability mechanisms, and as mentioned, can take various forms, each of them having its potentials and limitations. Let me illustrate how this works in practice on example of Ukraine. The Human Rights Council's Commission of Inquiry for Ukraine can provide a relatively fast, a broad overview of violations committed. Hello, do you hear me? Excuse me, I had an interruption. I'm back with you. The Human Rights Council's Commission of Inquiry for Ukraine can provide relatively fast a broad overview of violations committed, contextualize them, and provide insight into their causes and consequences. We will hear the first report of the Commission already this September. However, it cannot bring perpetrators to justice and can only help to launch legal proceedings. The legal proceedings before the International Tribunal Court, as well as Ukrainian and other national criminal courts, can prosecute and punish individual perpetrators, but these proceedings may take many years. Finally, the ICJ proceedings also take years, but in some cases may establish the state responsibility. So let me conclude. It is therefore crucial that the work of various accountability mechanisms is well coordinated and that taken together, they successfully address various aspects of accountability. Also, to be more successful in deterring atrocity crimes, we have to engage more into accountability-based atrocity crimes prevention diplomacy. Thank you.
Yeah, thank you very much for that, Ambassador Simonovic. I mean, I think that you raised a very, very important point, that it's different kinds of accountability mechanisms that can, when they come together, they can provide a sort of more holistic sort of view of what justice should look like or would look like, and are relevant at different times during the cycle of how justice is meted out. Akila, the same question to you.
Thank you so much, Savita, and really following up, I think, a lot on what Ambassador Simonovic is talking about. I'm going to focus on 2 points, one which is a challenge and one which is an opportunity. So starting with the challenges to get them out of the way. So one major challenge that we constantly find is getting actions that are truly intended to prevent or deter atrocities. I know we all know this from our work, but it usually takes for something to occur, something on a mass scale, before the international community will actually step into action. So as we talk about atrocity prevention, I think that's one challenge that we really have to grapple with, and from our work. So to me, Myanmar is very instructive here. Starting in 2010 until 2017, with the second wave of the acts that constituted the Rohingya genocide, there was consistent advocacy to the international community about the vulnerability of the so-called democratic transition in the country, ongoing conflict in ethnic states, and about the flawed and failed peace process, and systematic discrimination, oppression of the Rohingya. Calls for accountability, including from women with respect to sexual violence, were on the whole ignored. So when the Rohingya genocide occurred in 2017, we did actually see the international community step up in some form of action, including with the PRST from the Security Council, the creation of the fact-finding mission for Myanmar, and subsequently the International Investigative Mechanism for Myanmar by the Human Rights Council, And, recognizing the UN's failures in the lead up to the genocide, the UN actually commissioned a report which looked at the UN's involvement in Myanmar from 2010 to 2018, the Rosenthal report, which considered Myanmar to actually be one more case of systemic and structural failures of the UN, and included a series of recommendations for the UN system, most of which were not really taken up. And, satisfied with some of this action in the wake of the genocide, including movement forward on justice for the Rohingya, which I know some of my co-panelists are going to be addressing today, action towards the root causes of atrocities in Myanmar, which were outlined and detailed by the fact-finding mission, were limited at best. And just over 3 years later, we have a new crisis in Myanmar in the form of the February 2021 coup, which was the result of the long entrenchment of military power within the so-called civilian government of the country. Civil society had long been flagging this as a threat to the international community, but action to meaningfully address this was next to non-existent, and we were satisfied with responsive actions such as the accountability mechanisms created in the wake of the Rohingya genocide. And so in the wake of the coup, we've seen a little bit more. We've seen regular but closed meetings of the Security Council. We've seen sanctions imposed by a range of states. However, these actions due to stagnation of the Security Council have had a limited effect in the midst of crisis. And at best, I cannot wonder where we would be if the mechanisms of prevention had better been engaged in Myanmar earlier on. How many lives could have been saved? How much harm could have been mitigated? And so that's, I think, for me, the first challenge for us to really grapple with is how do we think about prevention as prevention, and how do we act in the years before these things happen rather than just in a responsive manner? The second is I want to focus on opportunities, which is really about the idea of how thinking outside the box can sometimes help to break political logjams and shift conversations. Some of this we've seen the way that UN institutions have stepped up when others were unable to act. I'm thinking, for example, of the creation of the IIIM for Syria by the General Assembly, or the IIM for Myanmar by the Human Rights Council, when the Security Council was unable to act on accountability for crimes in those two contexts. Or similarly, of the recent initiative in the wake of the Ukraine conflict, whereby an automatic GA meeting is triggered when a veto is used in the Security Council. So I think this type of thinking needs to be encouraged, because as we face structural deficiencies in the multilateral system, we need to look to how we can work to improve the system to actually make it fit for purpose. And in this vein, one initiative that I'm very passionate about and think is an important tool in the arsenal of atrocity prevention is the Draft Crimes Against Humanity Treaty. The draft treaty, which was completed by the International Law Commission in 2018, has essentially been stuck in the UN General Assembly Sixth Committee for the past 4 years as a result of a traditional practice of consensus by that committee. As a result, a few countries who've been opposed to the treaty have been able to exercise a de facto veto on movement forward. And as it currently stands, while crimes against humanity are prohibited under customary international law and can be prosecuted by the International Criminal Court, there is no explicit unifying framework at the international level on crimes against humanity, including for state obligations to prevent and punish, the ability to resolve disputes at the International Court of Justice, nor for mutual legal assistance and cooperation. And today, as we face situations on every continent that implicate crimes against humanity, deadlock in the Sixth Committee is depriving the international community of an important atrocity prevention tool. This doesn't have to be the way. We can again think about how is it that we break these logjams that get in the way of effective action. So for example, the UN Sixth Committee isn't actually required to act by consensus. They can and should vote in situations where consensus impedes the ability of the committee to execute its mandate for the progressive development and codification of international law. There are also opportunities to take this outside the Sixth Committee, or frankly, outside the UN system entirely. To me, the treaty is an important opportunity to improve the legal framework, and one where innovative and creative thinking is going to be necessary to make it come to life. I'll stop here.
No, thank you, Akila, for those really brilliant points. I think that you have said what was so essential, in the sense that how are we actually using accountability and justice in a preventive way? And from whatever we have seen over the last few years, I mean, we're not using it. And also to sort of outline some of the really sort of opportunities that are present today in the face of this kind of structural deadlock. That's really appreciative, and that's really very informative. So my next question now is to Karen Masuti and Arsena Suleiman. Karen, I'll go to you first, and then Arsalan, I'll come to you. So international justice institutions often have jurisdictional limitations that prevent them from prosecuting atrocity crimes committed in countries that are not members of the relevant international charters and conventions. Nevertheless, in recent years, states and institutions have creatively opened paths for addressing atrocity crimes that may otherwise go unpunished. ICC investigations and a case file at the ICJ regarding crimes committed in the context of Myanmar is a great example of this. So what are your reflections on the innovative use of international conventions to prosecute atrocity crimes? And what does this mean for the system of international justice more generally? So over to you, Karen.
Karen, you're muted, Karen.
Okay, can you hear me now? Great, I'm so sorry about that. I hope you can hear me clearly now. Yeah, so I just started by expressing gratitude to the organizers, the Vance Center and the Global Center for the Responsibility to Protect for organizing this event and giving me this opportunity to share my insights. And before I answer the question, I also just want to put a little disclaimer that today I speak in my personal capacity, even though you might see the ICC logo behind in my background. I'm really speaking not on behalf of the court, just in my personal capacity. And going to the question of jurisdiction, I just want to again allude to the obvious fact, which you mentioned in your introduction, that there are jurisdictional limitations to the ICC, and the ICC can only look at cases when certain jurisdictional requirements are fulfilled, such as the country in question being a state party or having filed a declaration accepting the jurisdiction of the court, or where the nationals of that state where the accused person is a national of a state party to the Rome Statute. And it also has to fulfill temporal requirements whereby the court will only have jurisdiction if the acts in question were committed after the entry into force of the Rome Statute for that particular state. And what this means is that a significant number of states are not covered by ICC jurisdiction. And if atrocity crimes are committed in those states, then there is a gap even which the ICC cannot fill. So what is the international community doing to try and address this gap? I think the first approach by the international community, and I think Ambassador Simonovic already alluded to this, are the various UN mechanisms that are coming up through commissions of inquiry, through independent investigative mechanisms being adopted and established by the UN General Assembly. All these are working together to try and close that impunity gap. But what I want to focus on today is what institutions like ICC are doing in regard to try and close this impunity gap. And that brings me to the case or the situation in Myanmar, which is currently under investigation by the court. What is unique about this situation is that Myanmar is not a state party to the ICC, is not a state party to the Rome Statute, but the judges of the court decided that because of the cross-border nature of the crimes, or the alleged crimes, the court would have jurisdiction because Bangladesh, which is a neighboring state to Myanmar, is a state party to the Rome Statute. And the judges determined that because of the cross-border nature of some of the crimes, especially the crime of deportation, for that reason, the court would exercise its jurisdiction over those crimes. So this is one innovative way in which courts and ICC in particular is trying to interpret the statute to ensure in an expansive way that allows it to assert jurisdiction even where ordinarily a state would not be under the court's jurisdiction. And another innovative way in which judges have looked at this is in regards to the scope of the investigation itself, other than the territorial expansion to cover the crimes committed, the deportation of victims basically to Bangladesh. The judges also decided that the scope would go beyond. The scope of this investigation was not just limited to the crime of deportation, but they authorized the prosecutor to also investigate any other crimes committed, at least in the partially on the territory of Bangladesh or any other state party to the Rome Statute. So again, apart from expanding the territory, the judges also expanded the scope of the investigation beyond just that exact cross-border crime of deportation. And with regard to the time period, even though the situation arose from the 2016-2017 waves of violence that allegedly took place in the Rakhine state in Myanmar, the court authorized the investigation of crimes allegedly committed after 1st June 2010, which is the date of entry into force of the Rome Statute for Bangladesh. Again, this takes the temporal jurisdiction way back to the period preceding the actual crime. And finally, the court also authorized the prosecutor to also look into possible future crimes that took place after the effective date of the atrocities. So this kind of allows the prosecutor to look at a very broad range of crimes, of course, as long as they have a link to Bangladesh, which is the territory that basically confers jurisdiction on the court. So from this, what I would conclude is that the way the ICC judges looked at this is very innovative and new, in the sense that judges are showing that it's possible, even with the jurisdictional limitations that exist in the current Rome Statute framework, that it is possible to actually interpret the statute in such a way that you can expand jurisdiction to include countries that are not states parties to the Rome Statute. And just briefly, I know I'm running out of time, just briefly, I wanted to also mention another point that is related to this. And this has to do with the principle of complementarity that is embedded in the Rome Statute. And I just wanted to mention that while the court has actually been implementing this principle from its establishment, in recent days, the prosecutor has been especially very proactive in bringing to life this principle of complementarity. He has recently signed agreements with Venezuela and Colombia, and most recently in regard to Ukraine, he has joined the joint investigative mechanism under Eurojust, joining forces with countries like Ukraine, Lithuania, to jointly work together to investigate crimes that have been committed under the ongoing conflict in Ukraine. This again enables the prosecutor to expand his reach and also facilitates the sharing of information and making investigations more effective. So with just these two examples I give, those are just my thoughts about creative ways in which, even with existing jurisdictional limitations, the court, ICC, and other tribunals could actually try to do more despite the limitations. Thank you.
No, thank you for that, Karen. That was really interesting to hear, and I hope that this kind of innovative way of moving forward, which the prosecutor and the judges have adopted in the case of Myanmar, can be replicated in other cases too. And I mean, we can learn more lessons from this. Now over to you, Arsene.
Thank you, Savita, and thank you as well to the Vance Center and the Global Center for the responsibility to protect for hosting this event. And thank you to my fellow co-panelists for their really insightful remarks. I mean, we've already heard, Karen talk about the ICC and its focus on individual criminal responsibility. We've heard Ambassador Simonovic talk about some of the UN mechanisms, including commissions of inquiry, fact-finding missions, and Akila has mentioned additional mechanisms like the IIIM and the IIM, which help to aid in these prosecutions. My remarks are going to focus a little bit on how you can try to address state responsibility through accountability mechanisms. And this, the primary way that this has sort of manifested itself thus far has been through judicial proceedings that are brought under certain treaties. And usually the judicial mechanism that's available under such treaties would be a dispute resolution clause, which allows a state to bring a case to the International Court of Justice if there is a particular treaty violation. Now, you mentioned, Savita, the nature of the restricted jurisdiction, and that, of course, is raised in this context in the sense that the ICJ isn't a court of general jurisdiction regarding all states. States have to give their consent to the jurisdiction of the court in particular circumstances. They can do so generally, but more often it is through specific grants of jurisdiction under specific treaties. And so we've seen in cases going back in history, like Bosnia v. Serbia and Croatia v. Serbia, where you have had states seeking to bring another state to the ICJ for the crime of genocide. And those two cases that I mentioned were specifically under the Genocide Convention. There have also been other claims and other cases brought under other human rights treaties in order to seek accountability for state responsibility for violations under those treaties. And there have been cases before the ICJ brought under the CERD Convention, the Convention on the Elimination of Racial Discrimination, as well as the Convention Against Torture. More recently, we've seen the Gambia bring its claims against Myanmar under the Genocide Convention for Myanmar's genocide against the Rohingya in Myanmar. And that has been a change in the usual pattern that we've seen in terms of ICJ disputes, because Gambia, of course, is not a geographic neighbor of Myanmar, nor are the Rohingya citizens of the Gambia. And in this sense, we've seen a state, the Gambia, bring a claim based on the erga omnes partes obligations of Myanmar under that particular convention, the Genocide Convention. And this is a bit of an innovative approach that the Gambia has taken because, as I mentioned, most of these types of cases before the ICJ brought to address or seek accountability for a treaty violation are more often brought by states party to that treaty that may be more geographically proximate or whose citizens may have been directly affected. And in this case, we have a case of a state which is a party to that treaty and which is seeking to have its rights under the treaty, which is the right to have other states held to account for their obligations under the treaty, their erga omnes partes obligations. And so that is a bit of an innovative approach that Gambia has taken. And I think the lessons that this case shows is that the responsibility for enforcement of these norms rests with the entire international community. It didn't have to be Gambia that brought this case. It could have been any other state party to the Genocide Convention, but it was the Gambia that decided to bring this case because really it was individual leadership within the Gambia that led that state in particular to want to take on this case and bring to justice Myanmar for its violations of the convention. But it doesn't have to be only the Gambia doing these types of cases. There are many other situations in which there are treaties that are available and that have mechanisms under those treaties in order to bring states before the ICJ to adjudicate potential violations of those treaties. And even in situations that are difficult, for example, in situations like dealing with the genocide of the Uyghurs in Xinjiang, there are certain treaty mechanisms that could be invoked to try to bring to account some violations that are happening. For example, there are various states that have complied with requests by the Chinese authorities to extradite Uyghurs back to China. And I think under any objective standard, the individuals in those cases should not be extradited because there's a high risk or almost certainty of them being subjected to torture in violation of the Convention Against Torture. And so in those situations where there is an individual who's potentially about to be extradited, you could have states bring a claim against the state that's potentially going to conduct the extradition to prevent that from happening under the Convention Against Torture. And I should also mention that the Convention on the Elimination of Racial Discrimination also has an interstate communication mechanism which could allow states to complain about the treatment of populations within them. It's not the same as going to the ICJ, but it is an interstate mechanism in order to seek accountability. And I think these mechanisms are certainly out there. It's really a matter of, will the international community step up? And will states take seriously their obligations under these treaties, which include obligations to take action to affirmatively prevent crimes like genocide from occurring? So we definitely need to, I think we definitely need to emphasize that global and shared responsibility. But in addition to the creativity of using these mechanisms, courage is really also really important. And I want to highlight in this context the courage of leaders within the Gambia that took this particular case against Myanmar to court. And I really think that it was the leadership of individuals like the Justice Minister at the time when the Gambia brought the case, His Excellency Abubakar Tambadou, and his experience as a prosecutor in the International Criminal Tribunal for Rwanda, that made him personally invested in using international justice mechanisms for accountability. And, you know, his personal leadership ability and vision allowed him to really lead his government to take this particular action, to file this particular case. And I hope that, you know, this case will lead to justice for the Rohingya in the sense of a finding by the ICJ that there is state responsibility for Myanmar's genocide against the Rohingya. But also I hope that it sets an example for other states that are parties to treaties and that can take similar action under the same erga omnes partes theory that the Gambia used to undertake this action.
No, thank you for that response, Arsenal. And I hope that we have member states watching, because, you know, Akila, Karen, and Arsenal are all putting forth these really creative ideas about how we can uphold our shared responsibility to protect populations from atrocity crimes. So I hope that states are watching and listening. And also, I really appreciate the point, Arsenal, that you made about, you know, individuals making a difference and the role that courage plays. I mean, I think it's political courage and political will in most cases that has led to, led to action. Even though we have a lot of mechanisms, a lot of treaty bodies, but, you know, we don't see that kind of action happening often. So courage plays an important role, and individual leadership plays an important role. My next question now is to Catherine. And Catherine, you know, it is becoming increasingly challenging to achieve individual criminal accountability for perpetrators of atrocity crimes, given procedural roadblocks, lack of political will, as we said before, as well as other limitations of the international system. As mentioned by some of the previous panelists, these limitations have led to the creation of a wide variety of bodies and innovative processes to try to fill the impunity gap. Given your expertise in victim representation, what are your reflections on these developments? How have the changes in the international justice landscape, particularly the increasing use of the principle of universal jurisdiction, impacted survivors of atrocities?
Well, thank you. Thank you so much for having me. As you mentioned, I have represented victims and continue to represent victims in a range of circumstances. I represent victims in cases against government officials, including US officials and US courts, I've represented them in foreign national courts under universal jurisdiction, as well as before treaty bodies and at the ICC. I've represented individuals against religious institutions like the Catholic Church when we're talking about the crime against humanity of rape and torture. I've also represented victims in civil actions against corporations. And I say that not to kind of highlight my CV, but to highlight the various places where victims have tried to seek justice and accountability. And what that justice and accountability, I want to emphasize, looks like for victims and survivors can be very different for each individual. For some, it is a criminal context that they want. For others, it's some form of reparation, including financial or community level reparation and rebuilding. But the one thing that to a victim almost, I always hear is the importance of non-repetition, that what happened to them does not happen to someone else. And this is particularly true in the context of torture. So I'm sorry to say that coming at the end of a lot of really positive and generative presentations, mine is going to be a little bit more negative, because what I have found through nearly 20 years outside of the UN system of doing this work is that I hit up against impunity, and I hit up against not just legal roadblocks, but political roadblocks. When you're trying to bring cases against powerful states, and that has included in my context, of course, the United States or the Catholic Church, or in light of the US relationship to Israel, representing Palestinian victims, or in the situation of Afghanistan, in light of the US war there for 2 decades, or in the context of Iraq. What I too often find is that it matters not what the law is that you're using, but who it's being used against. So even at the national level, whether we have a war crimes criminal statute or a torture criminal statute in the United States, it has not been used against US officials for what was a global torture program. It sounds a little strange to be talking about the torture program of the Bush administration in 2022, but as this panel is titled, "Where Are We Going?" you have to look at where we've been. And when the Attorney General of the United States is in Ukraine documenting war crimes, but we have had 4 administrations that have refused to look at and hold anyone of any level accountable for a global torture program, that sends a message. And it feels almost like rhetoric to talk about double standards and selectivity. These are substantive principles, in my opinion. Each victim deserves access to justice. And when a victim's right to justice turns on either their nationality or citizenship, or frankly, lack of citizenship, or who they're bringing the case against, the entire system then is called into question. We saw the United States sanction the International Criminal Court, the prosecutor, put her on a terrorist list and threaten criminal sanctions against lawyers like myself for trying to have some measure of accountability at the ICC. We know that the facts held up opening an investigation into the situation of Afghanistan, including the global torture program that occurred not only on the territory of Afghanistan, but also on the territory of member states in Europe and elsewhere in the Middle East and in East Africa. And this sanction program came into being at a time when the ICC prosecutor, the former prosecutor Fatou Bensouda, had found that there was also a reasonable basis to open an investigation into Ukraine. The ICC spent years pushing back against the political pressures, the threats, the sanctions, the cuts to its budget because of US pressure on that court. Ambassador Simonovic started out by saying, what if something had been done about Ukraine in 2014? I would say, what if something had been done about the US torture program earlier and had been done to rebut that pressure that was being put on the ICC? And it's not only on the ICC. We've gone to the Committee Against Torture with these cases, and we have lost. So it's not a question of a lack of law. It's really a question of lack of political will. Universal jurisdiction is very much in the discussions these days, and I'm certainly happy about that. I would like to see the law enforced. At the same time, I would like to see the law enforced for everyone. When we brought cases in France, Spain, Germany, Switzerland, Canada against US officials, those cases didn't proceed. There was an open investigation in Poland, and the Biden administration, not simply the Trump administration or the Obama administration or the Bush administration, but as recently as last year, the Biden administration went to the US Supreme Court and blocked the testimony of self-declared participants in the US torture program to contractors from participating at all in the ongoing investigations into Poland hosting black sites. So it's very difficult when you have the Biden administration on the one hand saying, yes, we support accountability for crimes committed by Russians, but then at the same time, actively blocking at home and abroad any efforts to hold their own accountable. We look at the universal jurisdiction situation in Germany, and there have been some very good cases and some very important cases from a victim perspective around Syria. At the same time, just a month ago, the German prosecutor ended a case brought by Palestinians in Germany, who were German citizens, into the 2014 assault and killing of civilians in Gaza. And you look at this and the words double standards can't help but come into your mind. So it's a very, very mixed bag. And I think from a victim's perspective, the engaging in these processes, including in fact-finding missions or commissions of inquiry, where people go through a process of telling some of the worst things that happened to them, having that documented in a UN report, and ultimately that the recommendations either being ignored or simply put on a shelf, that is painful. And then when the court proceedings are either stopped or stalled, and I would remind that the current prosecutor of the ICC said he would be, quote, deprioritizing the US investigation, the US torture investigation in the situation of Afghanistan. And he hasn't yet been in a position to push forward the ongoing crimes occurring on a daily basis on the territory of Afghanistan, particularly against women and girls. The message that is sent is that there is justice for some, but not justice for all. So I'm not sure what we need is more mechanisms. I don't think the barriers are necessarily jurisdictional in nature. What I think is a deep commitment and indeed courage. And I commend Gambia for what they did at the ICJ and elsewhere, but we need that across the board. When it comes to the situation of Palestine before the ICC, some of the very same states who have referred the situation of Ukraine, put in amicus briefs to argue that the situation of Palestine being a member state of the ICC, Palestine having done a referral of the investigation, that investigation should not proceed. So you have states who are refusing to cooperate, as was the case with the US torture program at the ICC. You have states that are using double standards when it comes to referrals and the principle of universality. So I think it's a challenging time for victims. And of course, even in those places where there is political will, we see the crimes going on a daily basis. So I think I've given some negatives there, so I'll stop now and certainly open to questions. Thank you.
No, thanks for that, Catherine, and thanks for sort of very starkly laying out the fact that there is such a hierarchy of victims. I mean, who is considered a victim and who deserves justice is so starkly informed by great power politics in the end, and lack of political will and all of those issues. So now my sort of the next pivoting is looking at the future a little bit, and this question is to all panelists, and maybe the order we can take is Akila, Arsenal, Kathy, I'm sorry, Karen, and then Ambassador Simonovic, to flip the order a little bit. So the range of responses to atrocities in Ethiopia, Myanmar, Ukraine, Syria, Yemen, and others have been quite varied and uneven, as Kathy very succinctly explained in a very different context. Based on your respective areas of expertise, what do you think are the key lessons learned that should inform future atrocity prevention initiatives, including accountability elements? What should be the main priorities of the international community and individual states when it comes to pursuing justice and deterring future atrocities? Akila, the floor is yours.
Thank you. I mean, I think this is the perfect place to pick up off of Katie's comments, really, right? Around the idea of the unevenness of what we've seen happen is a real reflection of the fact that it is a political game that we're playing and not one that is actually grounded in the frameworks of human rights that are supposed to guide decision-making and action. And so I think to really think about in the future, I mean, I can tell you how many times partners from Myanmar, for example, have said, they see what's happening with Ukraine. And it has been an unprecedented show of how when the international community wants to, they can engage every single tool in their arsenal, and they will do it. And you have victims from all these other countries, Savita, that you mentioned, Ethiopia, Myanmar, Syria, Yemen, who have gotten maybe pieces of this at best, but have just been told time and time again that justice for them, the prevention of atrocities against them is not possible. It's too big of an ask. Right. So I think the first thing we have to grapple with is how it is. I know we're structured in the multilateral system upon politics and around the preferences of what are alliances, what are economic dependencies. But I think it's really important to think about how we overcome this political preference issue, because we're not delivering justice. We're not delivering prevention for so many people around the world based exactly on what Katie was talking about, where they're from, what their citizenship is, who is committing acts against them, right? And so I think that to me is the first real challenge that we have to grapple with and think a little bit more about. And again, pulling from Arslan's points, this can be about states taking up more courage to execute what is within their power to do so. Right, to institute proceedings, whether under, in a human rights forum, whether it's within a, more of an adversarial forum in a court, to really think about how it is that we're engaging with these tools. I also think we have to think about some of the larger reform efforts of the United Nations, including around veto restraint and the legality of the use of the veto. I think those are the ones that really can help shift this narrative about this system and this framework being one that only works for some.
Arslan?
Thank you, Savita. I'll just, I think, make two comments here. I think one lesson learned is the importance of supporting documentation efforts. Certainly in the case of the Gambia's case against Myanmar, for example, the reports of the fact-finding mission were critical and really essential in order to enable Gambia to really bring forward the case. And so those types of mechanisms, whether they are UN authorized mechanisms like commissions of inquiry, fact-finding missions, or institutions like the independent investigative mechanisms, both for Syria and Myanmar, or other organizations that are doing the important work, journalists and human rights organizations on the ground that are doing the critical work. because those reports really do make a difference. That documentation effort and work is critically important once we get to these situations where justice mechanisms are activated. And so I think an emphasis on that element of the work is really important. And the second thing, is I think, we've been talking about the challenge and the problem and getting the political will and getting the states to act. And I think a different way of looking at it is the opportunity that's there, right? So there's an opportunity for the vast, huge number of nation states that we have in the world to really step up and become champions for human rights and become champions for accountability and atrocity prevention. And they can do so by using the tools that are available through various treaty mechanisms that they may be a party to, or in other similar ways. And so, I think the example of the Gambia, once again, is an example not only of that courage that is necessary, but also the opportunity that's there, because other states can also step in different situations and assert their leadership in ways that can really counteract the roadblocks that we've seen with other mechanisms. Akila mentioned the Security Council and the failures there. Well, if there is a mechanism available, and if a state is a party to a treaty which would allow this type of case to be brought, they can do it. So it's an opportunity there for states to actually take advantage of the mechanisms that may be available. And so I think that opportunity can be a focus for advocacy efforts to try to target, maybe states that are not the usual suspects in terms of international advocacy efforts.
Thank you very much for that, Catherine. The floor is yours.
Thank you. I appreciate both of the recommendations that just came and echo also around the UN veto reform, particularly when the issue before the Security Council is one dealing with mass atrocity. I want to see that happen. I think some of the ways to get around the politicization of justice and accountability is some objective roadmap. Something like the fact that a country can't be supporting efforts of justice and accountability for others until they deal with their own record of justice and accountability. And that could be based on fact-finding missions or commissions of inquiry, if those have documented and found a reasonable basis, to use ICC language, of war crimes, crimes against humanity, or genocide, and there has not been any kind of domestic accountability, then they shouldn't be sending off war crimes attorneys or using their resources for justice elsewhere. I think it's important to first have a requirement that states clean up their own histories before they can go elsewhere. And that's akin to something like we're seeing happened with Russia and the Human Rights Council, that a country can't be a part of a system of justice and a human rights system, again, until whether it's changes that need to be made by the Committee Against Torture, when they point out a gap like we have in the United States, where the US still does not have the crime of torture when it occurs on the territory of the United States. This is a consistent gap that has been identified. It's a little odd that we are ensuring that we have a legal framework to be able to hold non-US citizens accountable for torture elsewhere. So I think having a set of objective criteria, both normatively and then actually in practice, can help to take out some of the political stumbling blocks. And the last piece is one that again goes back a little bit to the Sixth Committee, but also some very concerning developments at the national level, and that's around immunities. The recognition of functional immunity, what's an official act, the fact that in some cases, things like torture have been found to be official acts, even when committed by another country's nationals. I think we need to be clear that when it comes to war crimes, crimes against humanity, and genocide, that these are not official acts.
Karen, the floor is yours.
Thank you, Savita. Just a couple of points for me. The first one, I think Catherine and Akila have really very eloquently explained the problem of the problem of double standards in investigations and prosecutions that we are all so much familiar with. And this, of course, working within ICC, this is a problem that we see everywhere. We see it at the UN, we see it in terms of interactions with different states. And I mean, it's a pervasive problem. I'm not sure that we really have a solution, but I believe that we could, as the international community, try to build a community that has a principled approach and commitment to accountability. I think that's the only way maybe we might be able to overcome the problem of double standards, where certain states will support certain prosecutions and then do everything they can to block certain prosecutions, even though the alleged crimes are similar. And just an anecdotal note on this, just in relation to the current events in Ukraine, I have been speaking with certain member states, so representatives of member states at the UN, who wonder why suddenly ICC has been starved of resources in terms of its budget. But in relation to the situation in Ukraine, there is suddenly a willingness to provide extra resources. And they are wondering, I think the issue for them is not that it's not good to do that, all accountability is good. But the question they keep asking is, why can't we do this for all situations across the board? And I think that's one of the problems the international community has to grapple with. But on that issue, and in the context of ICC, this also goes to the aspects of cooperation, which is mandated under the Rome Statute itself. Part 9 requires that states parties in particular, cooperate with the court. But there have been instances whereby states parties actually refuse to cooperate, and they do it openly, and they will have said in declarations and resolutions that we will not cooperate with the court. And there is really no mechanism for the court to enforce cooperation. And for as long as that cooperation is not forthcoming, successful prosecutions will always be a challenge, because a lot of the investigations and cases depend on the goodwill of states to provide, to assist the court with arrests and collection of evidence and in many other aspects. So that remains a challenge that as the international community, I think we are challenged to keep working on and find creative solutions for that. I, in my own personal interactions, I don't think I have come across any solution to that particular problem. The second issue I wanted to speak to is regarding burden sharing, and this goes back to the discussion I shared earlier on what the prosecutor is doing in regards to complementarity and the recent agreements with the national authorities and also with the Eurojust joint investigation team in terms of sharing, pooling resources and sharing the burden of investigation and prosecution of alleged crimes being committed in Ukraine. If these can be replicated in other areas where that has not been possible, I think we'll have more accountability in those situations, and we will have more resources available to ensure that, you know, there is full accountability in those other situations that are starved of resources or they don't have the capacity to be able to conduct those investigations under the principle of complementarity. So I'm really hoping that the lessons we are learning from the situation in Ukraine are lessons that we can carry forward and apply to other situations as well. Back to you. Thank you.
Thanks, Karen. Ivan.
I agree with a lot of comments, including ones on double standards, as well as suggestions of other panelists. To complement their great ideas, I would like to focus on a very specific and concrete proposal. Based on my personal experience that you mentioned, Savita, as UN Assistant Secretary General for Human Rights and Special Advisor for Responsibility to Protect, accountability-based atrocity crimes prevention diplomacy can achieve a lot, and we need to involve in it more. To put it simple, in situations of serious atrocity crimes threats, political and military leaders should be personally approached and warned to refrain from getting involved in atrocity crimes by ordering or not preventing and not punishing them. It is crucial that they are approached timely before they reach the point of no return. We need to engage more in the accountability-based prevention diplomacy. I was involved in it during my UN mandates, but we need to expand this crucial atrocity crimes prevention activity, make it more systematic and coordinated globally, regionally, and have right actors involved with it on both global and regional levels. Thank you.
No, thank you. And those were all fantastic points. And we have a question from the audience. It's from Mary Lemench, who is at the Montreal Institute for Genocide and Human Rights Studies. Mary asks the question, looking at different cases of mass atrocity crimes today, it seems that prosecution efforts need to be highly adaptable to local contexts, actors, existing agreements. How flexible must accountability efforts be to these local factors in order to achieve the goal of justice? Who wants to go first? The question is to all of you. I'll have to call on somebody then. Arshalan, why don't you go first? I'm putting you on the spot. I'm sorry, my dear.
No worries, no worries. Well, I mean, of course, they have to be flexible. You have to ensure that these processes, the investigations, the documentation efforts are tailored to the local situation, are conducted in a manner that is appropriate to local culture, local customs, you know, there's often a risk that there's a rush to try to get on the ground first and document or interview victims, and a lot of times that rush can lead to mistakes. And so, I mean, as part of that sort of broader issue, I think certainly any investigation, any process has to be specifically tailored to the local situation. But I think as a general matter, for those individuals who want to get involved in these kind of activities and efforts, it's important to get the proper training and guidance on engaging in this type of work in a way that is appropriate, particularly in terms of dealing with victims and ensuring that the victims' rights and their own situations are adequately taken into account and respected in the process.
Yeah, if I can build on that, in this context of mass atrocity, everything is and can feel very intense and very rushed, but I think it's very critical to have discussions at the start and again repeatedly throughout the process with the individuals that you're working with, asking, what does justice look like? What is it that you want? The words accountability always come up as what I want, but then when you start to unpack what that actually means, it means very different things, as I said, to different people. For some, it is not about them, it is about their community. And to go for a very individualized case in the name of an individual against another individual is actually harmful. Harmful not only risky and dangerous from a security standpoint, can break up a community, can break up a family. So I think it's important to really have those conversations and think quite creatively. Maybe the end goal is the ICC, or maybe the ICC is a tool for truth telling and a tool to expose systems of injustice, rather than a goal of putting someone in prison. So I think you do need to continually ask, what does justice look like, and what do you mean by accountability? Where I see less flexibility is actually in the norms. Everyone deserves the same basic fundamental rights: the right to be free, the right to be safe, the right to bodily integrity, the right to be free from torture, and obviously the right to life, including a life with dignity. That is where I think we need to be very clear that there are standards and norms that apply to everyone, but how and what justice looks like will vary. So the flexibility doesn't have to be around selectivity and lead to double standards. It has to lead to a meaningful level of justice for communities and for individuals.
Anybody else wants to come in? Akila, you want to come in from a gender perspective on this?
I think Ambassador Simonovic, and then I'll come in. Absolutely.
Please, Ambassador.
Thank you. To put a short answer to your question, we need to be adaptable to local factors, but sticking to universal principles. In our pursuit of accountability, we should not be neutral, but we should always be impartial. We should be always siding with victims, but be impartial in sense that we do not matter about nationality or political affiliation of neither victims nor perpetrators. Thank you.
Go ahead, Akila.
Yeah, thank you. And I mean, I think so much of what Katie said in particular about thinking about how you build the patchwork of justice and put it together, right? The different forms that it can take is important. I will speak kind of from a gender perspective. And so what it looks like when you look at something like justice through the lens of crimes that are often ignored or inconvenient or difficult and, you know, in different ways, right? So I think, and in today, what we see is that there's a real market for telling the stories of sexual violence. You know, people, it's the front page headlines, whatever story you're talking about. But when you start following the through line of who justice is delivered for, particular populations are often left out of who justice is delivered for, right? So crimes of sexual and gender-based violence are often used to form nowadays the narrative of the story. The shock value of the story are used to control the, you know, to say this is why something needs to happen, but they're often not meaningfully incorporated into strategies to actually deliver justice for those crimes. And I think one significant failure here is in thinking about who is brought to the table in the design of these conversations around what justice looks like. So to Katie's point of sitting down and talking to people about what does justice look like for you, what would you like to see? There are severe deficiencies in the participation of women in the design of justice processes. Oftentimes they'll be brought in as witnesses, they'll be brought in to tell a story, but that question of what do you want justice to look like, what would you like to see, often does not involve women. And so I think that's one thing that we really need to be thinking about as we design processes, the flexibility, what everything looks like, is about who is involved in the decision-making around justice, not just in the end point of who we think we're delivering justice for.
And if I may just very quickly, I agree with my fellow panelists on their views, but I just wanted to also bring in an aspect of flexibility, or rather adaptation, in terms of from an ICC perspective or from the Rome Statute perspective. I think it's really important that the local community and the victims in particular understand and buy into the accountability mechanisms, irrespective of where the venue or location of the actual accountability mechanism. And in ICC proceedings, one feature that really ensures that that investigations and prosecutions actually serve the interests of victims is by bringing in victims to actually participate in the proceedings, to speak there, to speak up and say what they think, how they see justice and accountability playing about. It gives them the opportunity to express their preferences and to tell their stories. And I think that's a very important aspect of making sure that justice mechanisms, especially when they are not at national level, are taking into account the views of the victims and the communities on the ground. Another feature that has not been used to date, but the ICC has tried to do this, but was unable to do it because for security reasons on a couple of occasions, is the possibility to have in situ proceedings in the situation country where the alleged crimes were committed. By bringing justice closer to the people, at least in situations where national prosecutions are not possible, you kind of bring the community, you make the community part of the process so they feel that they own it. It hasn't been possible within the ICC context for security reasons, but this is something that if implemented properly can also help bring justice closer to the people. But I agree that really it's really important for justice to adapt to or take into account the local situation. And as Catherine said, without, and Ambassador Simonovic as well, without compromising the universal principles on which the accountability is based. Thank you.
Thanks for that. And we have another question. There are currently 2 dedicated investigative mechanisms, one on Syria and one for Myanmar, that are mandated to prepare criminal dossiers for potential future prosecutions. And in both these situations, paths to justice are somewhat elusive. Now there are increasing calls for similar mechanisms for other situations where paths to justice also remain challenging, such as Yemen. What is your assessment of this stopgap solution? Are we headed towards a sort of standing mechanism that can collect and preserve evidence when paths to justice remain politically challenging? It's a long question.
I can maybe start on this one. So yeah, I think this is one of the things that are being grappled with, and there's some really interesting work, one that's being led out, a project that's being led out of Oxford, and another project that's being led by the International Commission of Jurists, both of which are looking at the advantages of having something like a standing mechanism or some sort of support mechanism to increase OHCHR's capacity to do this documentation work that looks at criminal standards rather than human rights standards. And so I think as we think about what this looks like, I think there's certainly many advantages, both from a very practical perspective of being able to deploy this type of documentation very quickly, working through different parts of UN bureaucracy, including thinking about issues like hiring, thinking about technology deployment, even the type of database that's used to collect the information, often which can, create a year-long lag or more in the operationalization of one of these mechanisms. I think that's really important. I do think that the part that's problematic and that we continue to push for is the creation of these bodies that document is really important, but we're doing it knowing that there's no venues to take these cases forward. And so in a way, it's good in that the information is being collected and documented, but these mechanisms have no public reporting mandate, right? So if there's no cases that are brought, they only really have the ability to cooperate with the court and share information confidentially with the court. So this information in a certain context could be collected to limited avail. And so I think as we think about what it is that we're doing with the innovation that is the creation of documentation mechanisms, which is very important and good, we need to not let that lull us into complacency that the creation of documentation mechanisms is in and of itself going to deliver justice. And that means that as states create these mechanisms, put financial and other resources behind them, they need to continue to push for the actual avenues for justice, whether that is something that is an ICC referral, whether that is support for universal jurisdiction cases, the creation of tribunals. That piece of the puzzle, I think, is being ignored in this conversation about documentation and really needs to continue to be thought about and pushed forward.
Catherine?
If I could just come in on this, what I think is needed out of these documentations is consequences. So whether that is the referrals to a criminal court or any other body, it can also be the form of sanctions. It can be the form of divestment to countries or to companies. I see the question there about Facebook. Documentation can't be an end in and of itself. So we see, again, I'm just taking the situation of Palestine, we see multiple fact-finding missions and commissions of inquiry that maybe contributed to the opening of an investigation, but this is now a 10-year process at the ICC that is not breaking the cycle of impunity. So to the extent that the documentation is not just a process for the sake of process, and I want to be careful here also, you know, in a field where there's creation of jobs, it needs to be something that is yielding concrete and meaningful consequences that break the cycle of impunity and stop the repetition of the crimes. So I think we can all be contributing to thinking what that might look like. Naming and shaming is not nothing. But it could be databases around companies or countries that you work with or don't work with. So some level of consequence beyond just referrals to courts, I think is an important component to build into whatever the studies are or the next phases.
You're muted.
Sativa, you're on mute. Yeah. Sorry, you're still on mute.
Sorry, still haven't mastered it. Ambassador Simonovic, please go ahead.
I was just intending to tell you that you are muted, but now that you have given me the floor, I would say that multiple accountability mechanisms can be both a curse and a blessing. Now it's on us to benefit out of potential blessing and avoid curses. In sense of blessing, quite often for some specific reasons, one channel for accountability is blocked. So let us then use the other channels. To avoid curses, we need to be well coordinated. I have seen, for example, in the field, that same victims were, there were different mechanisms and victims were giving their statements to multiple actors. We need to be better coordinated to avoid curses. Thank you.
Arsalan, you want to come into that question?
No, I think I'm okay.
Savita, if I may just very quickly add on to if I may add on to the important point just made by the ambassador regarding coordination and use of, avoiding the curse by using other mechanisms when one is blocked. And I go back to the discussion on universal jurisdiction that has been mentioned by several of the panelists. And I just feel that we are not, while this tool is available to many states, I believe the ones that at least have national legislation that allows them to use, to prosecute under universal jurisdiction. In my opinion, it's not being used enough and adequately. And partly it could be because there is really no coordination mechanism between states and also between the various international accountability mechanisms and national states, like for the investigative mechanisms and individual states in terms of making sure that the information that is collected, instead of just sitting and waiting for a time period when there will be a tribunal with jurisdiction to look at that particular situation. For instance, in the situation in Syria, whether they could actually encourage individual states to prosecute some of these crimes in their national courts under the principle of universal jurisdiction. I think we have tools, and I agree we are not making full use of the existing tools. I don't believe that we need new mechanisms. We need to find a way of ensuring that we actually make full use of what we already have. And we have a lot of tools available to us. Thank you.
Thank you very much. And I think that we don't really have any more questions unless until somebody wants to sort of address the Facebook question here, which is about how should the international community deal with social media companies. So unless somebody wants to jump in and answer that question or sort of address that issue. If not, then
well, on that issue, I do want to just make the point, not necessarily looking at accountability for potential violations that the social media companies may be liable for, but rather looking at their role in this idea of evidence. I think a lot of nowadays, because so much, the ubiquity of cell phones, handheld devices with cameras and video, and so many people sharing that content on social media platforms, including young soldiers and other people who may be perpetrators of atrocity crimes. It is, I think, important for social media companies to preserve such evidence of these types of atrocity crimes and ultimately make them available to the accountability mechanisms that are seeking to provide justice for those crimes. And this will differ under different legal systems, how those mechanisms are available to the various mechanisms that are seeking that particular, that are engaging in that particular accountability process. But I think there are steps that the social media companies themselves can and should be taking in order to build in their compliance with such mechanisms as part of their terms of service. For example, posting information that documents or is evidence of atrocity crimes. I think there are ways in which they could, within their own internal rules that are applicable to all account holders, they could ensure that that type of information would be available to authorities exercising the proper mechanisms to get that evidence. And also for actors, particularly state actors, who use social media platforms to engage in propaganda to support atrocity crimes, to engage in incitement to genocide and similar crimes. Those types of activities, I think, are uniquely problematic and requires unique attention by the social media platforms, because it's difficult for people to know that they are, for example, following an account that may surreptitiously be actually an account run by a state actor. And I think there have been different practices put in place by different social media companies in terms of how they respond to state propaganda. Some companies, I believe Twitter, for example, has an affirmative practice in which it puts content that it has identified as state propaganda or state kind of coordinated and authentic behavior publicly in a publicly available database. And I think Facebook in particular, needs to, they have done various takedown activities when they have uncovered coordinated inauthentic behavior, but the question of how that information could then be made available to justice mechanisms, I think, is an open one that's definitely worthy of more discussion and input into where they end up on that policy.
Catherine.
Thank you. Yeah, I think this is on that note, a bigger conversation about corporate liability writ large. And there is work going on at the UN Human Rights Council around a possible treaty for corporations. There's also discussion, and I think renewed discussion, about reopening the ICC statute to potentially have corporate liability. And I appreciate the positive things that were identified for corporations to do, but you also look at situations like Pegasus or Dark Matter. There are lawsuits against these companies right now, including by Arslan's firm in the case of Dark Matter, where surveillance of human rights defenders and actually contributing to the commission of war crimes and crimes against humanity. That's a very serious issue. And we have some states which have adapted their laws around war crimes and crimes against humanity to also include corporate liability. And then we have others, like in the United States, where we are seeing limitations on at least civil liability when it comes to extraterritoriality. So there are many legal issues at play here, but I think the key piece is that corporations have responsibilities, and they should also have liabilities, and we should be able to hold them accountable because they are part and parcel of this international system at this point, including the contractors who are working often on the ground alongside or maybe in the place of militaries, national militaries.
Anybody else wants to come in on that question? So thank you very much for this very, very rich discussion that we had today. I think it was really substantive, and we went into many different areas and sort of talked about the complementarity, and also sort of, as Vance talked about, the curse of having multiple mechanism and sort of the lack of coordination. But I again want to go back to the point that Akila raised, that how can we do better prevention work through these accountability mechanisms? And as Ambassador Simonovic again brought up, that sort of, approaching political leaders and sort of military leaders individually, and what kind of impact that could have. So, let's keep on working and keep on thinking about creative ways in which we can make justice accessible to all. Thank you very much for participating. You guys are all fantastic. I learned so much today. And also thank you to our global audience for watching it. I also want to thank the Vance Center for helping us co-host this fantastic panel, this fantastic event. Thank you, Mary-Claude, and to her entire team. And I also want to acknowledge my team, which is Jahan Pitalwala and Juliet Pava, for supporting and for organizing this event. So thank you, everyone. Have a great day and good evening.
Thank you, Savita.
Bye-bye, everyone. Thank you.